In this lesson, the last of 3 classes devoted to human rights violations, we will focus on the responsibilities these violations generate. We'll cover 6 points: human rights obligations, the concept of responsibility, types of responsibility, the legal responsibility of the state, the legal responsibility of the individual, and limitations to legal responsibilities. Under international law, states have undertaken the following obligations: to respect human rights, meaning not to violate them willingly; to ensure human rights, that is, to prevent their violations and to prosecute and punish the violations that do occur; to promote human rights, encouraging their respect throughout society, and to eradicate stereotypes and prejudices inimical to human rights; to progressively fulfill economic, social, and cultural rights to the extent of the state's economic means, and to cooperate with international human rights protection organs. Legally speaking, responsibility means to answer for a conduct in breach of a legal duty or obligation. When we talk about criminal responsibility, only the natural person who has committed an offense must answer, and no one can take this burden for him or her. It is possible, in some exceptional cases, to speak of the criminal responsibility of legal persons, like corporations, but we will not dwell on this point now. In private law, instead, what matters is not that the very person who did wrong be the one who answers, but rather that there is an actual redress, whether by the same person or by a third party, be it a natural person or a legal person. Both private persons and state officials may incur in legal responsibility, be it under criminal law or private law. Yet, only state officials are potentially liable for administrative responsibility due to a breach of their official duties, and only top state officials may have to answer for their possible political or constitutional responsibility through a process of impeachment or constitutional accusation. Liability stemming from human rights violations can be legal or extra-legal. By extra-legal responsibility, we mean moral, political, or historical responsibility. Moral responsibility emerges whenever moral standards of mutual respect between fellow human beings have been breached. Political responsibility takes place when a human rights violation causes a political party or sector a loss of legitimacy. Historical responsibility is the judgment of future generations regarding the conduct of political leaders or social sectors, such as the military, political parties, religious institutions, or even the whole nation. Moral, political, or historical responsibilities do not carry legal consequences, but moral ones, like rectifying institutional doctrines that are contrary to human rights, apologizing for past wrongdoings, and being willing to endure the burden of reparations. Yet, if such moral responsibilities have a great impact on society, there may be social pressure to pass actual laws providing for reparations or other measures. In the case of legal responsibilities, the subject liable for the transgression can be either a natural individual or the state itself. Whenever human rights violations are committed by a state official, the state is liable unless the conduct of the perpetrator is contrary to official policy or instructions, and the state has investigated and punished the transgression. Only actions by state officials may make the state responsible for human rights violations. If private individuals commit a violation, the state may be responsible only if it was done at the behest or with the connivance of state officials. State responsibility can be domestic if it stems from a constitutional or legal duty under national law to respect and protect human rights. State responsibility for human rights violations can also be international. Whenever the state fails to comply with a human rights obligation established in international law. A breach of international obligations can take place by an action or omission of any public official acting as part of the state. It does not matter if such official is a member of the executive, legislative, judicial, or other branch of the state. The breach of any obligation under international human rights instruments can give rise to state responsibility. Yet, in practice, claims against the state for human rights violations are mostly grounded in an alleged violation of the obligations to respect and to ensure. An individual who has committed human rights violations can be subject to criminal as well as to civil liability. Criminal liability can be pursued through different kinds of criminal jurisdiction. First, it can be obtained before a national court of law, even when the transgression has been committed outside the state boundaries, if the state considers itself entitled to exert extraterritorial jurisdiction based on the nationality of the victim and/or the alleged perpetrator. In cases of war crimes, a state can also exert the so-called universal jurisdiction without any relation to the nationality of the victim or the author whatsoever. Second, criminal responsibility can be pursued before international criminal courts, which can be of an ad hoc nature or can be a permanent tribunal, such as the International Criminal Court. On the other hand, civil responsibility can also be pursued under international and national courts. The most noteworthy example of the latter is the United States Alien Tort Claims Act, passed in 1789. This act allows foreigners to submit civil liability petitions before American courts against other foreigners. In order to seek social peace and reconciliation after times of deep crisis, societies often resort to measures of clemency. Pardons remove the punishment of someone convicted or liable to be prosecuted for a criminal offense. However, the legal responsibility subsists. Pardons can be general or particular and be established through administrative or parliamentary decisions. In many countries, they are a prerogative of the head of state. Amnesties, on the other hand, are measures that remove the criminal character of a certain act or acts for a given period of time. The statute of limitations is the legal impossibility to prosecute and punish a criminal or civil act due to the passing of a certain amount of time. There is an international norm prohibiting statutes of limitations for the crimes of genocide, crimes against humanity, war crime, and the crime of aggression. Furthermore, the Red Cross understands that the international humanitarian norm that calls for an amnesty after an internal armed conflict does not allow amnesties for war crimes. In recent years, there has developed internationally a strong current of opinion contrary to any measure of impunity for gross human rights violations. If impunity means that the perpetrators escape all consequences of their misdeeds, few would disagree. Yet it is possible to mete out justice combined with measures of humanity and national reconciliation. Please visit our website moocchile.com, and we cordially invite you to watch the next class of this course.